Good morning. We are back on the record in case number 2020-174. This is day 2 of the hearing. It's April 7th, 2021. I just want to make sure that we have all the council available and that everybody's audio is working, and then we have with us today Commissioner Matthews. Chairman Schmidt is unable to attend the hearing today, but we'll review the video later. Commissioner Matthews, can you hear us?
Yes, sir.
Perfect. Mr. Overstreet, Ms. Glass, Ms. Blend?
Yes,
Okay.
Your Honor.
Yes, Your Honor.
I see Mr. Spadar, Mr. Fitzgerald.
Morning, Your Honor.
Good morning, Your Honor.
Morning, Mr. Horn, Mr. Miller. So at least everybody can hear us. Maybe that's the most important thing. No. So at this time, as I understand it, the company had all of their witnesses taken yesterday. As I mentioned at the end of the hearing yesterday, our goal today would be to take Mr. Fitzgerald's client's witnesses first, given Mr. Fitzgerald's conflict this afternoon. He has 2 witnesses, I understand, or the joint interveners have 2 witnesses. Then we'll take AGKIUC witness Barron, and then the KYSEIA witnesses Inskeep and McCann. Does anybody have an objection to that?
No.
Okay.
No, Your Honor.
All right. Before we get started, are there any other housekeeping items that anybody needs to address or would like to address? Okay, hearing none. Mr. Fitzgerald?
Thank you, Your Honor. The joint interveners would like to call Joshua Bills.
Okay. Mr. Bills, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address.
My name is Joshua Bills, and address is 433 Chestnut Street, Berea, Kentucky.
Okay. Mr. Fitzgerald, you may ask.
Thank you, Your Honor. Mr. Bills, where are you employed and in what capacity?
I'm employed with Mountain Association as a commercial energy specialist. So we work with clients to review billings in terms of finding savings and evaluating energy efficiency measures and renewable energy measures.
Okay. Did you cause to be filed in this proceeding, in this supplemental proceeding, direct testimony and responses to data requests?
I did.
And if I were to ask the same data requests and I were to ask you the same questions that are in your direct testimony, would your answers be the same?
The direct testimony would be the same. I did find a minor typo in in the testimony. Sorry, the direct responses would have been the same. Typo I found was on page 5 of my direct testimony on line 20. It has it of December 12th, 2020. That should have been December 2nd of 2020.
Okay, and with that correction, are there any other changes that you would like to make to the testimony or to your data request responses?
No.
Okay. Your Honor, the witness is available for cross-examination.
Thank you, Mr. Fitzgerald. Ms. Fensel?
Oh, yes, thank you. Good morning, Mr. Bills.
Good morning.
In your supplemental testimony, you testified that TARIFF NMS 2 should be applicable under alternative retail rate options and not just the standard residential or the current commercial tariffs. Is that correct?
Yeah, that's an opinion just based on being able to take customers being able to have, options on what rates are available then to be supplied by, and not to be confined by those options based on the fact that they've invested in a solar generation system.
I have a couple questions I want to ask to build upon your recommendation. And what I would like to do is ask Mr. Leach and Mr. Rippey if they will please display PSC Exhibit 3. While they're doing that, I will say that this is Kentucky Power's Tariff RS TOD2, which is an experimental residential time of day rate that is in effect now. Mr. Bills, did you review this tariff as you were preparing your testimony? Or did you review this proposal at all just to get a perspective? And if not, that's okay.
I have reviewed that tariff
Okay.
before. I didn't look at it. Are you all able to hear me okay?
Yes, we can hear you. Well, then you've got some degree of familiarity with this tariff, correct?
Correct.
Okay. Is it correct that this tariff is seasonally differentiated?
It is. It appears to me that yes, that is seasonally differentiated.
So, looking here at what's on the screen right now, so there is different charges for summer, for winter, and for all other calendar periods, correct?
Correct.
Mr. Leach and Mr. Rippey, could you please take this down? And can I have you display Kentucky Power's response to Commission staff's 10th request for information, and it's item 14. And what this is an attachment to the question for item 14 that Kentucky Power filed. This is testimony from Kentucky Power witness Roush that was filed in a different case, but it is discussing the experimental residential tariff. Mr. Leach and Mr. Rippey, can I have you scroll down so that lines 15 to 19 are on the screen? Thank you. Mr. Bills, can I have you read lines 15 through lines 19 into the record?
Sure. The time periods were selected based upon an evaluation of Kentucky Power Company's load and also hourly market prices. The intent was to provide customers with a simple schedule, i.e. one that could be put on a refrigerator magnet that would guide their energy usage decisions based upon the most important hours from an operations and cost perspective.
Thank you. Mr. Leach, Mr. Rippey, you can take this down. Thank you. So, Mr. Bills, would it be a fair characterization to say that Kentucky Power based the experimental residential time of day rate on cost causation? Well, let me get a little more.
That could be.
Let me get a little more granular. Would you say
Okay.
that it was based on cost causation, including hourly market prices? Would you-
Based just what I've read and having no other information about it, one could conclude the likelihood of that.
Okay. Well, let me ask, would you agree that market prices can vary by season and by intraday periods?
Yes.
Well, based upon the thought that market prices vary by season and intraday periods, would you also agree that exported energy from NEM net metering customers, solar generating systems, could avoid different magnitudes of costs depending on the season and the day?
Yes.
And Kentucky Power's proposed export rate for NMS2 does not vary by season, does it?
It does not.
And although Kentucky Power has proposed 2 netting periods, would you agree that the proposed export compensation rate I'm sorry, let me withdraw that question. Would you say that the proposed export compensation rate under Tariff NMS 2 varies based on the time of day that the generation is exported?
Because there's 2 time bins, the customer's ability to take advantage of netting periods varies, but that's it. In other words, if there's excess generation during the NMS2 daytime period, that netting as proposed by NMS2 would be at a much reduced value from retail. And then the same would be true for the nighttime netting period, but depending on the customer's load shape, on how much they could use in those netting periods, is the basis for their return on each kilowatt hour that's generated. Right.
So the export rate doesn't reflect any variety in the intraday.
Right.
I'm sorry, go ahead.
I think I understand what you're saying, and that's correct.
Okay. Staff has no further questions for Mr. Bills.
Okay. For the intervener witnesses, we'll place Kentucky Power's questioning after staff's. So Mr. Overstreet, Ms. Blinn, Ms. Glass, do you all have any questions for Mr. Bills?
Ms. Blinn is available.
Okay. Ms. Blinn?
Yes, thank you, Your Honor. I am available. I do have I suppose, a question in terms of procedure. Will the company have an opportunity to ask additional cross-examination based on the cross that's going to occur by counsel for interveners, given that the company has the burden of proof in this case?
My expectation is that we'll go around twice. Let me just ask this: are you saying that your preference would be just to be the last party to cross-examine the witness?
If that would suit the commission, that would be my preference, yes.
That's fine.
And it may cut down on the amount of cross.
That'd be fine. That'd be fine. So if you'll just
Thank
wait then, and we'll go through and see if anybody else has questions, and we'll come back to you.
Thank you.
All right, Mr. West? Any questions?
AG's office has no questions for this witness.
Ms. Cohn?
No questions, Your Honor.
Ms. Grunman?
No questions, Your Honor.
Not Mr. Fitzgerald. Mr. Spinard?
No questions, Mr. Vice Chairman.
Okay, Mr. Miller?
No questions, Mr. Vice Chairman. Thank you.
Mr. Fry?
No questions, thank you.
Okay. Commissioner Matthews, do you have any questions?
I don't have any questions, thank you.
I don't have any for Mr. Bills, or actually, I need to. None for Mr. Bills. Ms. Blinn, do you have any questions for Mr. Bills?
I do, thank you. Mr. Bills, you were just asked some questions about the company's experimental residential service time of day tariff. Do you recall those questions?
Yes.
Okay. And I believe you testified that you had previously reviewed the RSTOD tariff. Is that correct?
Yes.
Are you aware that that tariff has been in effect since 2009?
I was not aware of the date that that tariff took effect.
Great. Are you aware that there have been no customers who have taken service under that tariff since it was put in place in 2009?
I have not, I'm not aware of that.
Are you aware? Sorry, I didn't speak over you.
That's fine. We've evaluated a number of clients that have had demand usage interval data for consideration of that option. And we haven't come across a client that had the load profile that made sense to choose that rate class in the handful that we've monitored.
Okay, thank you. Are you aware whether the rates set forth in the experimental residential time of day tariff are cost-based rates?
Can you ask that again, please?
Sure. There are rates set forth in the experimental RSTOD tariff that you were questioned about.
Mm-hmm.
Are you aware whether those rates are cost-based?
I'm not aware that that is the sole driver of those rates, but it does make sense that cost basis is a part of it.
Sitting here today, would it be fair that you don't know whether they are cost-based or not?
Just in terms of rate making itself and the cost basis to drive that rate making, as a general rule, that I don't, I don't have the specifics on what aspects of the cost drove that rate.
Have you ever prepared utility tariffs?
No.
Have you ever participated in utility rate making in terms of establishing rates to be included in the tariff?
Have intervened in cases, but have not participated in a full cost of service study that drove, that was the basis for those rates.
Okay. You were asked some questions about market pricing earlier by Ms. Ginsel. What is your experience? What experience do you have with regard to PJM markets?
Just that we watch for any opportunities for aggregation of demand response for customers that might participate in a demand response marketplace. In terms of our clients, we have clients across multiple utilities, served by multiple retail utilities and cooperative utilities. So those that are in the PJM market, we will review any opportunities to participate as a retail customer in those aggregation of those programs.
Okay. Do you know if on-peak power costs $190 a megawatt hour?
Somewhere, at some time, for somebody.
So your testimony is yes, it does.
Can you be more specific in the question?
Sure. You've talked about that you're familiar regarding PJM markets and that you follow them. My question to you is on peak power in PJM, does it cost $190 a megawatt hour?
I can't say definitively when that has happened, but it would not, it could have happened.
I have no further questions. Thank you.
Ms. Vincent, do you have any additional questions?
Staff has no further questions.
Okay. Mr. Fitzgerald?
We're fine, no redirect.
Okay. Thank you, Mr. Bills. And unless there's an objection from staff, I think you may be excused.
He may be excused.
Okay.
Thank you.
Mr. Fitzgerald, your next witness?
Thank you. Our next and last witness, I call Carl R. Robigo.
Okay. Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury? We're not getting your, I don't know that we're getting your audio.
I'm gonna try that again. I have my phone on mute. Can you hear me now?
We can.
Okay. And I do want to confirm that I stated that I do swear or affirm that the testimony will be true.
Okay. We're getting a little bit of background.
I noticed that too, and I'm not sure what we can do about it. Maybe the system will settle itself down. Is that better?
Yeah, that's better right there. Okay. So we'll just go back and do the question again if that's okay. So if you don't mind to raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do, but I am still getting a lot of background noise. Perhaps I should switch to the computer audio.
I think it might be from Fitz.
I was just going to say, Your Honor, I think it might be Fitz's computer.
Oh, good.
Okay, that's much better. We'll blame it on Mr. Fitzgerald. He'll be okay. Do you mind to please state your name and address for the record?
Yes, sir. My name is Carl Robigo, and I work at 2025 East 24th Avenue, Denver, Colorado.
Okay. Mr. Fitzgerald, you may ask.
Thank you, Mr. Vice Chairman. Where are you employed and in what capacity?
Yes, my place of employment, I am the principal of Robigo Energy LLC, a Colorado limited liability company. I am the principal and sole employee, and I provide consulting services in electric utility regulatory matters, sometimes gas regulatory matters, and do a fair bit of work in sustainable biofuels as well.
Thank you. Did you cause direct testimony, supplemental direct testimony to be filed in this action, and did you respond to data requests that were propounded to you?
Yes, sir. I did cause that testimony to be prepared, and I did prepare responses which you submitted on our behalf in this proceeding.
I'm getting blamed again. If I were to pose those same questions to you, and if you were to be asked the same questions for your direct testimony, would your answers be the same?
They'd be the same or substantially the same, yes.
Okay, and do you have any corrections or changes to make either to the data request responses or to your testimony?
No, sir, I do not.
Okay, witnesses available for cross, Your Honor, thank you.
Yeah, and before we begin, Mr. Robigo, can I just ask what documents or information you may have in front of you today?
Right now, the only document I have in front of me is my testimony, which was just referenced. I do have, since we're doing this on a computer, I have access to electronic files from the case. If you need me to pull something up, or I can reference something on the screen.
All right. Thank you, Mr. Robigo. Ms. Fensel?
Yes, thank you. Good morning, Mr. Robigo. In your supplemental testimony, you discussed the National Standard Practice Manual for benefit cost analysis of distributed energy. Wanted to make sure I get the title right. For the purposes of this cross-examination, would you object if I just call it the manual?
I would welcome that. It's a mouthful of a name.
It is. Is it correct to say that you consider the manual to contain the best practices for net metering rate design?
Yes, that was both the intention and I believe the result when we wrote it. I need to be clear. I'm sorry, you said for rate design. It is a manual intended to be best practices for benefit cost assessment for distributed energy resources, DERs. My testimony is that good benefit cost assessment or analysis is fundamental to coming up with and developing fair and reasonable rate programs that utilities offer. And that was the thrust. We thought that was going to be one of the primary uses. Of course, many other uses be made of benefit cost analysis, but for the purposes of my testimony, I was trying to explicit between the two. I would say also my prior work, value of solar analysis, which is essentially benefit cost assessment. Well,
No, thank you. That is an important distinction, and I will make sure that I reference this correctly. So let me back up to say again that you would consider the manual to contain the best practices for a net metering benefit cost analysis.
Yeah, for a benefit cost analysis to inform a net metering rate design.
Thank you. Is it fair to say that in your supplemental testimony implies that Kentucky Power's proposed tariff NMS2 fails to align with the best practices that are set forth in the manual?
That is fair to say, in two reasons. Number one, be comprehensive in assessing all of the impacts of benefits and costs. Second of all, it does not rest on a foundation of sound data, which, as I pointed out, would have been in a true, complete of service study, not just analysis or, data assessments or other sub-analyses of the costs of serving both generating and non-generating customers within a class.
Thank you. One of the guiding principles that you discuss in your testimony, and again taken from the manual, is the need to conduct forward-looking, long-term incremental analysis. Can you explain a little further or expand upon why you believe this principle is important when designing net metering tariffs or in the benefit cost analysis?
Yes, ma'am. And that is principle 5. It is briefly discussed on page 17 of my testimony. And it is important because a distributed energy resource, in particular, a net metered customer generation facility, is going to be operating in all likelihood for 25 or more years. Therefore, it's going to be impacting the grid for that long, the distribution grid and in increments, the entire grid. It's going to impact generation, as Mr. Phillips discussed yesterday, at some level, in a cumulative effect, these facilities will change the load and will change the load that the utility manages. So since that's going to be happening for 25 or more years, then we ought to be accounting for that impact, just like we account for the impact of any resource that the utility would install for the purposes of meeting load and serving customers. Now, this ties to principle number one, which is that, you should be treated and evaluated as a resource side by side with other investments the utility makes. I would also point out that this is a fundamental difference with a pure cost of service method in a jurisdiction that uses historical or embedded cost rate making. Because in effect, if all you do look at cost of service, even if you did the full cost of service that we don't have in this case, you would be looking backwards. And that has the effect of essentially assuming all fixed costs are sunk, meaning they're in place and they can never be changed. That, of course, is not true physically, factually, or economically. So one benefit of doing forward-looking analysis is that you can capture the way in which an alternative resource will change the pattern and level and timing of fixed cost investments in the future. Something also that I heard discussed yesterday, I believe in discussion with, I think it was Mr. Phillips from the company.
No, thank you very much. You've touched on a couple of my questions, so I'm going to look through, make sure I'm not duplicating, but thank you, that was very helpful. Based on your experience, do utilities factor in future environmental compliance costs when evaluating beneficial resource procurements?
That's a great question. Utilities generally will factor in the future costs of current environmental regulations as part of the energy cost. In a competitive market, it will show up in the LMP or dispatch costs. Sometimes pretty often actually in IRPs, utilities will project forward-going environmental compliance costs as well, but those are forward-going current compliance costs. Many utilities still take the somewhat backward view that it's not a real cost if it only appears 5 or 10 years from now, or at least it's not a cost worth estimating, and that any such cost is a societal cost that should not be evaluated in utility decision making. I take issue with that because it really impacts that future looking assumption about the resource. And I think that even if it's not strictly known with 100% certainty, we've gotten very good at estimating and at least bracketing the costs of future environmental compliance. The elephant in the room, of course, is carbon and costs that will be associated, ultimately paid by customers everywhere if their utility is still depending on carbon-emitting resources 5, 10, or more years from now.
Thank you. You mentioned yesterday's testimony from Everett Phillips and some questions to him about avoided distribution capacity costs. And in your supplemental testimony, among the cost and benefits that you listed were avoided distribution capacity value, correct?
Yes, ma'am.
And as we discussed yesterday, Kentucky Power did not include the avoided distribution costs in TARIFF NMS 2, correct?
That's my understanding.
Also, yesterday, we discussed that for Kentucky Power, some of the distribution costs are specific to unique locations. Would you agree that because avoided distribution capacity costs, or some of them are locationally specific, that could mean that benefits could be created at a specific substation?
Yes. So the first thing I'll note is that a whole lot of site-specific distribution costs are spread to all customers according to the allocation of such costs and the factors used in the rate making, and the cost of service study. So, maintaining, putting in place, if the utility absorbs the cost of putting in place increased poles, wires, transformers for a new suburban housing development, that cost is may or may not be allocated to the developer. It may in fact be shared with all other customers. We could get into a whole debate under the theory that it spreads existing fixed cost benefit for everyone. That's the old argument for load building. But in terms of locational value, kind of a holy grail issue that we first wrote about when, I remember first running into this when I was at Rocky Mountain Institute about 20 years ago, in which we looked at utility data and found that the marginal distribution capacity cost among these varies widely by feeder. And it can be that in some places where congestion or growth is increasing rapidly, that distributed resources can contribute very high value. When we worked on the value of DER rulemaking in New York, when I was there at the Climate Center, we specifically, and the commission specifically worked on developing a locational value that the utilities would calculate for these locations, well, distribution value for the grid as a whole and over the term. And of course, the most acute locational and temporal value is manifest in what we call non-wire solutions, where a suite of distributed resources, having everything, storage, and distributed generation, can be cited to address and defer, as Mr. Phillips mentioned, or actually even a huge CapEx problem. The famous Brooklyn Queens project that Con Ed did about 5 or 6 years ago now showed how you could use just a few $100 million worth of DER to $1 billion worth of substation changes. So that's the holy grail out there of location-specific DER deployment, and it can be captured in a good benefit cost assessment.
Mr. Robigo, I think you've covered all of the questions that I had for you, so no more questions at this time. Thank you very much.
Thank you.
Mr. West?
No questions for us.
Ms. Cohn, do you have any questions? Ms. Grunman?
No questions, Your Honor.
Mr. Spinard?
No questions.
Mr. Miller, any questions on behalf of the Sierra Club?
None, thank you, Your Honor.
Mr. Fry?
No questions, Your Honor. Thank you.
Dr. Matthews?
No questions.
Mr. Rob, I've written down the Robago. Mr. Robago, in your experience, are there in this? I don't know if you were watching yesterday when we talked about that electricity journal article written by the folks at the Brattle Group. They talk about there's two primary ways to determine, we'll call it the impact of net metering customers on the rest of the the system or non-participating customers, the cost of service approach and the cost benefit approach, right? It seems like you're discussing it from the cost benefit perspective rather than the cost of service perspective. Let me ask, in terms of benefits of distributed generation, particularly as it relates to net metering customers here, are there benefits that are not avoided costs?
Yes. I think the economic term, I'm not an economist, but I think the term the economist, like my friend Dr. Faruqi, who wrote or co-wrote that piece you're talking about, would refer that as a positive externality. So what we're talking about is benefits that are not captured in the traditional approach and that in fact impact the overall sort of wisdom, if you will, the positive versus negative of taking a particular action. The one that we really, that there has been some debate about, which is, I'll specifically point to, is tax, economic development, and job benefits. We know that distributed resources produce far more local economic benefits than utility scale resources on a per megawatt basis. And many utilities ironically, avoid calculating that value because they claim those are societal benefits. But of course, many utilities are part, and their customers are part of society, and their jobs, the jobs they help create, are important to all of us. But that's the classic example of a kind of benefit. There are also other benefits that cost of service, as I talked just a few minutes ago. If you stick with the paper's simple breakdown of cost of service versus benefit cost assessment, as I mentioned, you will exclude a wide range of future benefits if you're relying solely upon the embedded or historical costs captured in a traditional cost of service analysis.
It sounds like the Bluetooth hitting.
Hold on one second, Mr. Robigo. I think we have I don't know, but somebody that needs to be muted that's joined by phone.
Yeah. CO showing up as call. There they go.
Okay.
They're muted now.
I think those are all the questions I have. I appreciate it. Thank you very much.
Thank you, and congratulations on your confirmation. It's a great relief to have that, isn't it?
Thank you. It's nice to wake up one morning and know you have a job. So,
Yeah.
I appreciate it. Mr. Overstreet, Miss Glass, Miss Blend, I don't know who. Kentucky Power.
It's me, Your Honor, Mark Overstreet.
Please proceed.
Thank you. Good morning, Mr. Robigo.
Good morning.
My name is Mark Overstreet, and I'm counsel for Kentucky Power Company. I don't believe we've met. I just have a very limited set of questions for you. It's my understanding that you're not an attorney. Is that correct?
Oh, no, I am an attorney.
Okay, you are an attorney. Okay, I'm not going to ask you.
I'm sorry, I want to be very clear because you know how we lawyers are. I am on inactive status, licensed to practice, not licensed inactive with the Texas State Bar, but I received my law degree in 1984 and have practiced as a trial attorney in the United States Army, as a law professor, as a regulatory attorney, but now I'm happily not signing anything attorney at law.
Okay, thank you for that correction, and I was using that as a predicate to indicate that I'm going to avoid trying to ask you legal questions. But are you
I'm willing
familiar?
to take a shot from you.
Surely. Are you familiar with KRS 278.192, which describes the Kentucky practice in rate cases for test years?
I don't have it committed to memory. If you want me to search for it and pull it up, or if you want to talk to a specific section, I'd be glad to discuss it.
Well, all I was going to indicate is that the statute provides that a utility, in filing its rate case, shall use either an historical test year or a future test year. Does that sound about right?
Yes, it does. That is relatively common. I'll point out, even a future test year approach is typically a statistical extrapolation of historical test year data or historical data. But we've always, even with historical test years, we've always made adjustments, and measurable adjustments when it gets to a rate fix.
And are you aware that in filing its application, in this case, Kentucky Power filed it based on an historical test year?
I am not aware of the method they specifically chose in this regard. I focused on the cost data that was used and put forth on the net metering proposal only.
But for purposes of its application in this case, will you accept that Kentucky Power filed using a historical test year?
Yes, sir. If that's what you say the company did, I'll accept that, subject to check.
Thank you. Is it not true that the commission, in approving the rates it approved in its January 13, 2021 order, relied upon that historical test year data?
I really can't speak to it. If that was the test year data, and if it was not altered in the course of the commission's order, then the order would be based on that test year data. That I put a lot of ifs in there because I'm really not 100% sure if it, what was proposed, as you said, survived completely to the order, but assuming it did, yes.
Are you aware of any aspect of that order where the commission looked 25 years out in making any sort of adjustments?
I'm assuming that there were lots and lots of places where the commission looked 25 years out, because if not directly, indirectly, because capital assets that were included in the rate, in the depreciation costs that the company put forward for historical investments, in many cases probably have useful lives out that long. I'm thinking poles, wires, and other infrastructure. But was there direct adjustment? I do not know.
Okay, and I was asking, just to be clear, about a direct adjustment for a benefit that might occur 25 years out.
Yes, I'm not aware of one, but again, I really had a pretty narrow look at the case.
Thank you. That's all the questions I have.
Ms. Vince, will Mr. Robigo be excused?
Yes, you may be excused.
Thank you, Mr. Robigo.
But Vice
Oh,
Chairman?
excuse me. I'm sorry, Mr. Fitzgerald. I apologize. Would you?
Thanks. I just have a very few questions on redirect. You are familiar with what's been called the Brattle Group report that was appended to the PSC's order in the 2019-00256?
Yes, sir, and the one referenced by Vice Chair Chandler?
Yes, yes. I just wanted to follow up. Do you agree with the methodology and the conclusion that was reached in that paper?
No, I don't. I think my major concern is the one I expressed in response to staff questions, which that it basically by choosing the cost of service approach, it essentially treats fixed costs as being sunk. Second of all, the paper itself it builds on another paper that Dr. Faruqi wrote in a previous journal, a previous edition of the Electricity Journal, in fact, in which I also had an article in which he put forward his idea, this assumption that there's always a subsidy to net metering customers. So it just becomes sort of a case of, can we spot it and size it? Second of all, it makes a number of assumptions because it doesn't have data in trying to come up with a numerical thing. It makes estimates about free net metering consumption levels by customers. It makes estimates that include scaling up consumption on the assumption that all scaling up consumption levels for net metering customers based on the assumption that all net metering customers use more than the average amount of electricity, and a couple of other areas. So I just think a benefit cost assessment is better for the reasons that I also discussed with staff. But one thing I do want to iterate really strongly, though, and I think Vice Chair Chandler it was Vice Chair Chandler that addressed this yesterday toward the end of the day. The method makes it clear that doing a good job on assessing whether there is a subsidy and the magnitude of any subsidies in which direction they flow is critically dependent on data, and especially data of net metering, non-net metering customers within the class. And that's a focus of my testimony as well.
Thank you. I have no further questions, Mr. Vice Chairman.
Okay. Thank you, Mr. Robigo. You may be excused.
Thank you.
Mr. Fitzgerald, do you have anything else?
No, Your Honor, that is, those are the only witnesses for the joint interveners.
Okay. So I'll turn to Mr. West or Ms. Cohn as to the availability and introduction of Mr. Barron.
Yes, we have Mr. Barron available.
You may call him.
I believe he's on the screen if you'd like to swear him in.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Please state your name and address for the record.
Stephen Barron, it's J. Kennedy and Associates, Inc., 570 Colonial Park Drive, Suite 305, Roswell, Georgia, 30075.
Mr. West, you may ask.
Thank you. Mr. Barron, what's your role in this proceeding?
I originally presented on behalf of the Attorney General and KIUC testimony in the first part of this case, and among the issues I addressed was a discussion of the company's proposed net metering changes, and particularly the payment rate for exported energy. In this part of the proceeding, my role has been just primarily reviewing testimony, supplemental testimony by the company and parties, and I did sponsor a data request from the staff.
Okay. So
Or
You-
response to the staff's.
Yeah,
data.
response to the data request. Okay, thank you. And with regard to that response or those responses, do you have any changes or corrections you need to make to those at this time?
No, I do not.
Okay, and if you were asked by the same questions by the staff at this time today, would your answers be the same?
Yes.
Okay. The witness is available.
Thank you. Mr. Barron, before we get started, do you have, could you explain to us what documents you have there in front of you?
Well, I have, I guess, various documents. I have a copy of the data response that to the staff's second data request to the AG and KIUC. And I have some work papers from the original case and some excerpts from some of the testimony that have been submitted subsequently, supplemental.
Okay, thank you. Ms. Vincent, do you have any questions for Mr. Barron?
Staff has no questions for Mr. Barron.
Okay. Ms. Grunman from Walmart?
No questions.
No questions? Okay. Mr. Miller, Mr. Spinard?
No questions, Mr. Vice Chairman.
None, Your Honor. Thank you.
Mr. Fry, do you have any questions for Mr. Barron?
No questions, Your Honor.
Mr. Fitzgerald, any questions for Mr. Barron?
No questions for this witness. Thank you.
Okay. Dr. Matthews?
No questions.
Mr. Overstreet?
No questions, Your Honor.
Okay. Making your day easy, Mr. Barron and Mr. West, and staff, Ms. Nance, Ms. Denzel. Can Mr. Barron be excused?
Yes, Mr. Barron can be excused.
Okay. Thank you, Mr. Barron.
Thank you, Mr. Vice Chairman.
Is there anything else from KIUC or the AG?
We have no further witnesses, Your Honor.
Okay. So, Mr. Spadard, I'll look to your box here. You're in case you're curious, you're in my top left-hand corner. It's like what was that show?
Hollywood Squares?
Hollywood Squares. Thank you. You're the top left-hand corner here. I think if we can try to go ahead and get one of your witnesses in before we take our first break of the morning, that would be great. So I'll turn to you to call your first witness.
Certainly. Good morning. CASIA calls to the stand Benjamin D. Inskeep.
Okay. Mr. Inskeep, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
My name is Benjamin Inskeep. My business address is 1155 Kildare Farm Road, Suite 202, Cary, North Carolina, 27511.
Okay. Mr. Spinard, you may ask.
Please state who you represent and your role in this proceeding.
I represent the Kentucky Solar Industries Association. And pardon me, what was the second part of your question?
And your role in this proceeding.
I provided expert witness testimony on behalf of CASIA.
Thank you. And if I ask you the same questions, your expert in your testimony, if I ask you the same questions today, would your answers be the same, with the note that the CASIA has filed on your behalf an errata sheet into the record that contains 3 modifications, updates, changes? Would your answers be the same, adjusting for those, for the errata sheet?
Yes, they would be the same or substantively the same.
Okay. And you also responded to various data requests in this proceeding, is that correct?
Yes, that's correct.
And if I were to ask you the questions that were propounded to you in those data requests, would your answers be the same today as they were in those data requests?
Yes, they would be.
Okay. And will you please explain the information that you have in front of you?
Certainly. I have my testimony that's been filed. I have some portions of the testimony that the company has filed. I have my information, my responses to information requests, and I also have some notes.
And with that, the witness, Cassia, tenders Mr. Inskeep for examination.
Okay. Ms. Vincel, do you have any questions for Mr. Inskeep?
Yes, I do. Thank you, Vice Chairman. Good morning, Mr. Inskeep.
Good morning.
In your testimony, you discussed legacy rights, and I have some questions. I'm sorry, I just heard some feedback. I have some questions for you regarding that. But first, I want to distinguish what we're talking about. In this statute, Kentucky statute, that the net metering statute, there is a provision, a legacy rights provision for net metering customers who had facilities in operation prior to a certain point in time. I want to set that aside. That's not what I'm referencing. When you provided supplemental testimony, you spoke about legacy rights, which one way to think of it is more prospective. That is, if the commission were to approve certain rates today, and then the question is, then what happens in the future? How often are they updated and so forth? Does that make sense to you if I call legacy rights that more prospective?
Yes, it does.
Okay. You had some good information in your testimony. I appreciate it. Can I ask you to expand upon the concept of legacy rights, what the issues are, and what the benefits in particular are for customers and potentially for the utility?
Certainly. Thank you for your question. Legacy rights are, I think, a very critical part of considering policy changes when it comes to distributed energy resources, because as Mr. Rabago was just mentioning, these are assets that are going to be on the grid for 25 plus years. And so when a customer generator, a customer of a Kentucky power company makes that investment and puts in, for example, a solar net metering system, they're putting forward that system for a long period of time, and they, in order to make such a large investment, they want to have some sort of certainty or be able to predict what that financial payback period is going to be, what are going to be the economics of that, and maybe not to a perfect degree, but at least have some reasonable idea of whether or not this is going to pencil out for them and what those benefits are going to be to them. The reason why in my supplemental testimony and my direct testimony I advocated for legacy rights provisions for customers on any change to the NMS tariff, such as NMS 2 if it's adopted, is because the Kentucky Power Company has indicated it plans to frequently update the export credit rate that it's going to provide customers for their net excess generation for the netting periods. And that's going to do so on every 2 years. So, for example, a system that lasts 30 years, you're going to have that credit rate change 15 times. They also indicated that if they install AMI meters, they might plan to propose a change to net metering where instead of having these 2 netting periods, they're just going to go to an hourly or a reduced netting time period. So instead of over the whole billing month, they're now going to be offering a lower credit rate within the month for any exported energy. So for example, if a customer is installing a net metering system today, and they're under that 2-period netting system under NMS 2, 2 years from now, the company could come back and propose a change to that where they're moving to a more instantaneous sort of netting system. And so that could dramatically change the situation for those customers, and they wouldn't be into any sort of legacy rights program. In response to data requests, the company said that it would not give these customers any sort of protections. They wouldn't let them stay on that rate. It was subject to change. And so when we're thinking about how to protect customers and treat them fairly, we want to make sure that we're not exposing them to dramatic risks when it comes to such a long-term investment that can benefit not only themselves, but other customers on the grid through their exported energy.
Knowing that the statute sets forth a 25-year time period of protection, is there any particular time period you think would make the most sense to protect legacy rights?
In my opinion, it would make sense to also set a 25-year period for NMS 2 or any other subsequent tariff, just to maintain that consistency with the legacy rights period that NMS customers receive within the statute. And also that time period reflects a kind of a typical system life, or at least a performance guarantee for solar panels that are currently in place among many solar panel manufacturers. So that 25-year period does coincide well with kind of the long, expected life you would have for an asset like a rooftop solar system.
And I believe what I heard from you, I just want to see if I can break it down a little bit to make sure. When we're talking about legacy rights, there are almost two components. The first is the rate amount itself, and then the rate structure. Is that correct?
You could consider, I would clarify that maybe there's some additional items that I would also include within legacy rights. One example being the netting period, or the number of periods within your netting period. The company has proposed this kind of 2-period time of use netting within your billing period, and so I would also include something like that. So if a customer is getting retail rate net metering over the monthly billing period, I would say that you would, within the legacy rights, you would expect that the billing period would be that netting. That's how the netting would be determined going forward for the next 25 years for that customer. But yes, I would also agree with your point that the rate design is definitely an important component, as is the export generation credit for either any exported energy over the monthly billing period, or under NMS2 over the two netting periods, or the two billing periods. Pardon me, the two netting periods. And one other item that occurred to me, I think I also mentioned this in my supplemental testimonies, is things like when it comes to rate design, things like the time of use window. You would probably also want to have some sort of provision considering that as well. And so if a customer is on a design that is treating their rates or their export credits based with a higher value for certain periods than others, you would probably want some sort of consistency over time for that as well, so that a customer isn't installing a system thinking that the exports are going to be benefited in one way and then have that change in 2 years or 5 years or something, in a way that would materially and negatively impact that investment.
Thank you very much. Staff has nothing further.
Mr. West, any questions for Mr. Inskeep?
No questions for Mr. Inskeep, thank you.
Ms. Cohn?
No questions, Your Honor.
Ms. Groman, any questions?
No questions, Your Honor.
Get back on our normal schedule here. Mr. Fitzgerald, any questions for Mr. Inskeep?
No questions, Vice Chairman. Thank you.
Mr. Miller?
Done, thank you, Your Honor.
Mr. Fry?
No questions, Your Honor, thank you.
Dr. Matthews?
No questions, sir.
We've got a few, Mr. Inskeep. So I am aware, I'm recently aware, I think maybe both from your testimony and Dr. Faruqi on Twitter, about what California has done in terms of net metering, right? They basically set a date, and everybody before that, it had, we'll call it classic net metering, right? And then now there's this subsequent net metering, and I'm sure you know the name, but we'll just call it version 2, right? And version 2 is fairly defined, and at least there have been some calls for coming back and reviewing it for some sort of version 3 based off of, we'll say, the impact of what maybe version 2 looks like. Now, I don't want to draw parallels between Kentucky and California because, they have building codes, that are tied specifically to rooftop solar. They have a, Cal ISO is significantly different than either MISO or PJM. But I guess my question is, looking at what California did with legacy rights, are you aware of instances in which specific utilities, rather than statewide programs, have created legacy rights? And I ask that, before you answer, I ask that from the perspective of a utility may come in here, say Kentucky Power, propose a change to their net metering rates and not be back for 2 or 3 years, right? And for another rate case. Another utility may come in and it may be 12 years before they come in for the second time after they've renewed or gotten the new net metering. So, I just ask that in the context of it's going to be utility by utility difference. Are you aware of any instances where that's the case with providing legacy rights to new net metering changes?
Subject to check. I'm not immediately sure off the top of my head. I would want to research a little bit more closely to fully and accurately answer your question. I think there could be some examples. For example, in California, you have a number of smaller utilities that are not their large investor-owned utilities that ended their first iteration of their net metering program and then created new programs. So those could be examples, but I'm off the top of my head, I'm not immediately sure. So I can't point to any specific examples at this moment.
Okay. And I want to go back to a couple of the questions Ms. Vincel was asking about maybe not necessarily quote unquote your proposal, but what you were speaking to in your testimony. So we've got the rate that customers are charged due to the provision of service from the utility, right? The ordinary rate that at least in this case applies to residential customers is proposed to continue to apply to any MMS2 customers. Then there's separately than that the compensation rate for net exports over certain time periods, right? And there's 2 time periods in which it applies. It's a kilowatt hour denominated value, and well, I guess that's the entirety of it, right? So there's a 2-part rate design that's applicable for the residential class and residential net metering, same with commercial net metering. And then there's this time differentiated kilowatt hour denominated value, right? Are you proposing legacy rates for all of those proponents and not just the amounts, but also I don't know what the word I'm looking for is, but also the same attributes, right? That it's continued to be a kilowatt hour denominated over, time differentiated netting over those 2 billing periods, and they continue to receive the same residential charge.
Let me try to clarify, and let me know if I'm not correctly or not answering your question. I'm not suggesting that, like, for example, a residential net metering customer be locked into the rates, the exact rates that they currently have for 25 years.
Okay.
Rather, when it comes to legacy rights, I think it's important that customers continue to have a similar rate structure. So that would be continuing to have their per kilowatt hour charges along with a customer charge, and not be subjected to a major shakeup in that design, 2, 4, 6 years down the line, such as, the company indicated, I believe that, they're interested in considering things like a residential demand charge and moving to a 3-part rate as opposed to the current 2-part rate that's more common among utilities in this country for residential customers. And so that could have like a large and significant negative impact when you're talking about retail rate net metering. And so that's the kind of legacy rights that I think that a net metering customer would particularly benefit from. Whereas a customer today, would assume that, the rates could change over time. They might see slight increases over time. And that's, perfectly normal and something that, any net metering customer would expect. What they wouldn't expect is to all of a sudden be subjected to a major new design in the rates, mandatory time of use design or new demand charge, that kind of thing. And so that's what I was really going with my recommendation on maintaining the rate structure for legacy rates customer.
All right, so let me ask about that then. So are you proposing that they maintain the current structure, or are you proposing that they maintain the identical structure to a non-participating residential or commercial customer? Because let's go the other way. Right? Let's say in 3 years or 4 years, the commission decides, they do an investigation or based on a company filing, to go the other way, that instead of doing a 3-part rate design, that it should be a 1-part rate design, and that a customer should just be charged for all of their usage on a kWh basis with no monthly customer charge, right? Are you saying that your proposal with legacy rates for these new NMS2 customers is for them to maintain the current customer charge and kilowatt hour charge, or to maintain that they have the same rate design for net usage, let's call it that way, for net usage as non-participating residential or commercial customers?
So I think the legacy rights proposal would be for a customer who installs a net metering system now, who has that rate structure with per kilowatt hour charges and a customer charge. They would continue to be able to take service under that kind of a rate structure going forward for that legacy period. So if there was a change in 3 years, for example, where there's a new tariff created that is going to be the default residential service tariff that moves everything to a per kilowatt hour charge, no more customer charge, for example, the legacy net metering customer would still have the option or still have the right to take service under that original rate design that they took service under. So the company could update those specific components to reflect the cost of service. So your fixed charge might increase slightly, and your per kilowatt hour charges might increase slightly in that legacy rate design for that customer. Whereas all the other residential customers might be defaulted onto this new rate structure that you're referring to here. And then, my recommendation would be that a legacy rights customer would have the option to, opt out of their legacy rights at any point in the future and say, okay, yeah, I'm going to get off that legacy rights structure and take service under this new option that's being offered. And, if they did so, that would be their choice, but they wouldn't be able to revert back to the legacy rate design after they did that. Does that answer your question?
I think it does. So it's the rate structure in effect at the time, not necessarily the basis of the rate structure in effect at the time.
I think so. I'm sorry, I'm not quite sure.
Well, the reason that NMS2 customers are being charged the same customer charge and kilowatt hour charge is because they are part of that homogeneous either commercial or residential class, right? That's what we heard from the company. So they're charging them the same customer charge and residential charge as the rest of those classes, non-net metering customers in those classes. And I just want to make sure I understand, you're not proposing that they continue to be part of that homogeneous group for rate design purposes. You're just saying that they should have that rate design set in stone now, regardless of whether the rate changes, but the rate design for those NMS2 customers shouldn't necessarily float with the rest of the homogeneous residential and commercial class, but should be kept at the same structure as proposed today, or as defined by the commission in this case.
Yeah, that's right. And the reasoning goes to just having some sort of stability for these customers, that if they're making this large investment, that they're not going to be subjected to a major shakeup that would negatively impact them, and make that large investment no longer pencil out for them after the fact, after it's too late for them to go back and make that change. And particularly if it's a type of rate design change that isn't very foreseeable by the customer when they're making that original investment.
Okay, and let's go to the other side of the equation. So that's for their net, net usage, we'll say, right? For the exports, is it a proposal that, let's say the commission agrees and approves the time differentiated netting periods, right? I think that's probably the right term for them, but the time differentiated netting periods and providing a benefit on a dollar per kilowatt hour net export basis, right? Are you just proposing that exact structure be maintained, or that structure and the rate be maintained, or the structure and the the inputs, let's call them, into that rate be maintained?
So typically, my understanding is from other state examples where we've seen this type of change to net metering happen, is that they'll allow a customer to lock in a specific rate at the time that they're interconnecting their system. And so that, if that export generation rate it goes down in the future for new customers that subsequently take service under that, the customers who originally installed the system aren't going to see that rate float downward and negatively impact that value of the system. So my legacy rights proposal would be to allow that customer to lock in whatever that export credit rate is at the time they are interconnecting their system, so they have some sort of stability or certainty about what that payment is going to be.
Okay, and also the structure, so structure and rate.
I think that's fair to say, yes.
Okay, and so the only parallel that I can draw here, and I know Mr. McCann talks about the PPA, and I'd like to talk to him about that, is the idea of a QF, right? That at least at a high level, that's what the company seems to try to be treating the net metering customers as a QF that has these, a QF without a buy all sell all, basically. At least as it relates to the energy charge, right? And my understanding is that the amount paid on the energy front, even if it's not LMP, even if it's some avoided energy cost that's updated routinely by the company, that unless there's, we have in our regulations the opportunity for somebody to take one of these floating QF contracts, right, where they may not be dispatchable or for some other reason, and the amount that they're paid for avoided energy updates, it's calculated the same way, right, for that utility, for the duration, but it's updated with new data because the avoided energy costs may change from year to year or over a 3 to 5 year period. So that's different than what you're proposing for these net metering customers, and I'm just curious if you have a concern with consistency between the commission having the difference in those rates.
Well, I would say that the treatment of QFs is kind of a separate and distinct issue from the net metering program, which is a separate program and is limited to customers 45 kW or less, whereas QFs under PURPA are up to 80 megawatts and are dealing with oftentimes larger and more sophisticated merchant generation. So I think one important consideration is the fact that when we're talking about the net metering program is we're talking about, for the most part, residential customers, often rooftop solar systems. We're not talking about independent merchant generators who might have some more sophistication to be able to analyze, changing energy prices and wholesale power markets. And so I think that's why, for a customer such as a net metering customer, having a little bit more stability in their rates is beneficial and worthwhile. So I don't see necessarily a large concern with having different treatment for customers under different tariffs that the commission has for different types of distributed generation facilities.
Yeah, so as I read FERC's orders on QFs, the idea being that they're recovering their the certainty they have in recovering costs is usually on the capacity charge, which is why it's mandated to be, at least 5 years fixed, I think. So I guess I would just ask, in terms of your view on the net metering changes, is that the basis for your proposal on the energy charge? Is that's that certainty, or is there another rate component that performs that task or function?
I'm sorry, I don't think I quite followed the question. Can you repeat that?
Yeah, so QFs are provided a 5-year fixed payment, a capacity charge, right? That's fixed at the outset as a general matter, that they can use to, get financing similar to the 3-year forward markets PJM uses for the capacity market, right? You hear generators all the time saying, please, let's run this next BRA because we need to go out and finance, and we can't finance unless we have these, defined fixed payments that we know we can get. That gives you some sort of certainty for the recovery of your capital investment, right? There is no fixed capacity payment proposal in NMS. So I guess what I'm trying to understand is that the reason, is that parallel between that, that needing certainty, is that the basis for your proposal on fixing, the compensation rate, for these legacy customers?
If I understand you correctly, I believe the answer is yes, that this is for similar reasons, just like a QF needs to have the right amount of certainty in order to finance a project. A residential customer needs to have the right amount of market stability and certainty about how they're going to be compensated going forward in the future to know if the system is a worthwhile investment for the 25-year plus life of the system. In that if there is no, if there's a lot of uncertainty and there is no ability to confidently project forward how they're going to be compensated for any excess generation, it can be really difficult to make the economic argument for it because there's going to be a lot of risk that is going to be pushed onto that customer. And so that risk, I would say, is not appropriately balanced by shifting it all onto the net metering customer and having that rate, float, wildly from year to year or be adjusted significantly every couple of years, for example.
Okay. Those are all the questions I have, Mr. Inskeep. Thank you. Mr. Overstreet, Ms. Glass, Ms. Blend.
No questions from the company, Your Honor.
Okay. Mr. Spinard, any redirect?
No redirect, Mr. Vice Chairman.
Okay. All right. Thank you, Mr. Inskeep. Can Mr. Inskeep be excused?
Yes, you can.
Thank you. Mr. Spinard, at this time, it's 10:37 is what I have. Let's take we'll call it a 13-minute break. Come back at 10:50. And then you all can introduce your what I believe to be your final witness.
Yes, Mr. Vice Chairman.
Okay. We'll be in recess. All right, we're back on the record in case number 2020-174. Mr. Spinard, are you here?
Yes,
Okay.
Mr. Vice Chairman.
Dr. Matthews, are you here?
Yes, I just can't seem to find the mute button on my 3 screens.
It's okay. And Ms. Blend, are you ready to start?
Yes, Vice Chairman.
Okay, great. Mr. Spinard, you may call your next witness.
Yes. Casilla calls Richard McCann.
Mr. McCann, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
My name is Richard J. McCann. My address is 426 12th Street in Davis, California, 95616.
Mr. Spinard, you may ask.
Please identify who you represent and the role that you have in this proceeding.
I represent the Kentucky Solar Energy Industries Association. I am a partner with M Cubed, a economic consulting firm in California. My role is to discuss the valuation of net metering contracts and rates in the Kentucky Power Company service area.
Thank you. And did you cause to have filed in this proceeding prepared supplemental testimony?
I did.
And at this time, do you have any corrections, modifications, or changes to that testimony?
Yes, I have a minor one on the title page. I misattributed who I was testifying on behalf of. Just a correction, a typographical correction. Should be the Kentucky Solar Energy Industries Association Incorporated.
Thank you. And with that change, if I were to ask you the same questions today that were asked in that testimony, would your answers be the same?
Yes, they would.
And have you responded to data requests propounded by the commission staff and the parties in this proceeding?
Yes, I have.
And if I were to ask you those same questions propounded in those data requests today, would your answers be the same as the responses that have been filed?
Yes, they would.
And will you please identify the information that you have in front of you?
I have my supplemental testimony. I have the data responses in which I participated in that were submitted by the KYSEI CASIA, and I also have open my computer folder that has my work papers available, as well as notes that I've taken during the hearing.
Thank you. And at this time, CASIA tenders Richard McCann for examination.
Ms. Fensel, do you have any questions for Mr. McCann?
Staff does not have any questions for Dr. McCann.
Okay. Mr. West, any questions for Dr. McCann?
The Attorney General doesn't have any questions, Your Honor. Thank you.
Okay, thank you, Mr. Horn. Ms. Cohn?
No questions, Your Honor.
Ms. Grunman?
No questions, Your Honor.
Mr. Fitzgerald?
No questions, Your Honor.
Mr. Miller?
No questions, Your Honor. Thank you.
Mr. Fry?
No questions, Your Honor. Thank you.
Dr. Matthews?
No questions, sir.
Dr. McCann, I have a few. Good morning.
Good morning, Your Honor.
You discuss in your, we'll call it supplemental testimony, but in your testimony, the parallels between NMS2 customers or customers taking under tariff NMS2 and purchase power agreements with counterparties in or out of wholesale markets, right?
Correct.
Okay. So are NMS2 customers in your mind a generator or a ratepayer or a user?
They stand as a hybrid. You may have heard the term the prosumers. We're in a new environment in which we have customers who have also now become generators, and how we approach dealing with them in rates and policy will have to reflect how that is changing. Certainly we do have a parallel with the self-generation based QFs, which actually started producing with the onset of PURPA back 40 years ago. And that offers us some guidance. But in addition, we now have much smaller consumers who are not as financially sophisticated, who are also participating in these markets. And so we need to be thinking about what kinds of assurances we give them, the consumers, that we also give to producers that make large capital investments relative to their own financial position. And so that's the basis of the parallels between giving the generators PPAs and how we should be treating consumers who are net energy meter customers.
Okay, so on the example, the first question that came to mind was, in your example, is the purchaser or the counterparty to the PPA, the purchaser of the PPA, existing in a monopsony situation?
Oh, absolutely. In this case, the Kentucky Power is the monopsonistic purchaser from the consumer, the net metering consumer. There is nowhere else for them to turn and sell their power. It's not even like in the PJM situation, in which there is some alternatives in the hourly market. Or in particular, a generator can actually choose between different locations to interconnect in the very first place. They can choose different locations that are based on their expectations about differences in LMPs. If you own your house, you own your house. You do not buy your house based on where you want to put your solar panels.
Right. And then on the flip side of that, though, in this situation, isn't it the case that as opposed to the PPA, hypothetical, that there's only that besides being the monopsony from the utility perspective, the utility is under an obligation to accept applicants for net metering that meet the qualifications, right? There's no willing buyer or willing seller in this situation.
There's obligations to buy. There's also obligations to sell on the flip side from the consumer. And in large part, also the utility and the other consumers are protected by the 1% cap, the existing cap on buying or having installations of NEM facilities. So that there's not a great financial risk on the side of the utility. And in California, where I am now, that's the same. It worked the same way. The NEM 1.0 contracts had a capped amount that the utilities would get to, and they, in general, for example, I'm in the PG&E service territory, Pacific Gas and Electric, and they reached their cap in late 2016. At which point, then it rolled over to the NEM 2.0, and I am, in fact, myself a NEM 2.0 customer. I am on a TOU rate and for my solar output with particular structures for that. And now California is approaching, I'm not sure if they have a cap on the NEM 2.0, but it's always been understood that they would then roll over to a new generation of NEM rates. They're going to move on to the NEM 3.0, in which that proceeding is currently underway, and they will probably have a new rate structure by the end of this year. So if you can have built-in caps in your rate structure, so that when you issue a certain number of contracts, you roll over to a new structure that can potentially protect the exposure of the utility and exposure of other non-NEM customers going forward.
So I guess what I'm trying to understand is the parallels between a PPA situation and where there probably isn't monopsony or market power, right? It's a willing seller and a willing buyer with that likely have alternatives in wholesale markets that if they didn't want to do a PPA, they could go get what they needed from a wholesale market versus a situation to where there is a monopsony. There's an obligation to sell for the customers and an obligation to buy from the utility. Why should the NEM customer under that situation be treated identically to the PPA, even though they're not similarly situated, and that the markets they participate in are maybe as different as can be?
So there's many different flavors of PPAs out there, and in drawing this parallel, I was making a comparison between what Kentucky Power is proposing in its NEM NMS 2 tariff, which is basically turning those customers into spec customers, something akin to the generators in Texas who rely entirely on revenues from the ERCOT market and are fully exposed to the variations in the spot market and in the short run capacity markets. And that kind of situation is one in which the NMS2 customers would be at a distinct disadvantage compared to any other customers that or any other generators in the marketplace who actually have a range of different types of PPA options available to them. So, for example, a larger generator can sign a QF contract if they want, which has terms, differing terms. In California, we have 5 different kinds of QF contracts. I'm aware that you may have one, but it's possible to have many kinds. Or a generator can go to KPC and sign a bilateral PPA with fixed term prices over several years, even out to 20 or 30 years. In addition, KPC itself has the ability to lock in an investment when as was described, I believe, by Witness Vaughn yesterday from the company. He described how KPC compares any of their generation investments against expected market values. But he didn't include one key piece, which is once KPC decides that the new generation resource will surpass the hurdle rate for the current market value, that's based on a forecast of market value. The generation does not change its earning rate over time over the next 30 or 40 years. They are able to recover their investment for the next 30 or 40 years at essentially a fixed recovery rate. They are given a one-time market valuation, and that market valuation is the one that is used going forward for a number of years. What's in the NMS2 tariff is a market valuation that is constantly changing. And that is where there's a very distinct difference between the treatment of the consumers who are on the NMS2 contract and the range of treatment that is given to generators. I think that Mr. Inskeep's previous answer about how he is expecting or proposing a structure for the NMS tariff, which has a consistent structure and has some variation in the rates and predictable variations in the rates, is one of those intermediate points in terms of contract terms that the commission should be considering.
Mr. McCann, Dr. McCann, excuse me. short of what I understand that your proposal is to, I strike that. I understand your proposal to be effectively convert the current kilowatt hour charge that's being charged to those customers and make that the compensation rate. Is that correct?
I'm not exactly following those.
Well, so let me take a step back. What is your recommendation as it relates to the commission's, to the commission's decision in this case to create a compensation rate for net exports for NMS2 customers?
I don't have a specific proposal because I think that what has to happen is that the company needs to do a full cost of service study along the lines of the benefit cost study that was discussed in the Electricity Journal article that you have referenced in the previous decision, so that you are able to actually measure the full sets of benefits and costs that are associated with this contract. And then I think that you need to construct a rate that appropriately shares the risks between the company, the NMS customers, and other customers as well. And so I don't have the information. I don't think the commission has the information yet to construct that kind of rate at this point. But I think that is the type of rate that you want to move forward with, because I think that those kinds of issues are ones that are key to developing a fair and equitable rate for these customers that also protects the really key interests of all the parties.
Okay. So let me ask about the company's proposal here, your opinion on it. As I understand it, they've decided that in terms of the cost to serve, they'll continue to charge those customers for net imports at the rate they're charging other non-participating residential and commercial customers. Is that your understanding as well?
When you say net imports, are you talking about usage or
Yes.
exports to the company?
Usage.
Usage, yes.
Okay. And then for net exports, they've produced a compensation rate that's time differentiated between two periods based off of effectively determined avoided costs. Is that your understanding?
Yes, so they're right. They're based on their metric at using the PJM market price benchmarks. Yes.
Okay. And so if a determination is made to use a cost benefit analysis to determine what the appropriate compensation rate is, right? Is that then a net compensation rate that's netting the costs and benefits of those net metering customers? Or the conclusion of a cost benefit analysis, does that necessarily have to change the rate in which a customer pays for those net imports or usage?
That's an interesting question in that I have not been thinking about those two distinct elements in that way. I think that you'll be wanting to look at the cost of service for those customers. It may be that you will want to make a distinct class, or it may be that the transaction cost of doing that is too high and that you still have to rely on the average cost of service for residential customers. So I don't have a recommendation specifically on.
I guess what I'm asking is how do we both include the exact same cost in a determination in the cost benefit analysis, and then it would seem circular to me to determine costs in a cost benefit analysis and then also determine those costs in a embedded cost of service study, class cost of service study, because either you're reflecting the cost twice, first as a net to the benefits to determine the appropriate compensation rate, and then again including those same costs in the cost to recover from the customer, right?
I think that you're able to net out the one set of costs from the other as long as you're aware that you're doing that. I don't think that it's that difficult to avoid double count
Okay. And so, other states that have used the cost benefit, do you know if they've maintained the residential rate for usage?
No, I'm not aware of the exact details of how other states are doing their rate structures in that way.
Okay. And if you're holistically considering the costs and the benefits, should it then be a buy all, sell all situation, or should the customer still effectively retain the ability to net the usage rate in those time periods when it's a net exporter?
They should be able to retain the net benefits of that. And in particular, as the configuration of solar systems change and that customers are more likely to be having direct connections to storage in the future, they should be able to internally use that power. One of the most likely scenarios actually in this case is the expansion of use of electric vehicles. Because electric vehicles are likely to be one of the cheapest sources of on-site storage available to consumers in the future. So they are likely to have configurations where they have direct service from the panels to the charging of the vehicles, and then the vehicles are then able to, through the V2G technology, be able to power the house when the cars are parked. And cars are parked about 95% of the time.
So you still propose then, even if you determine what the value through a cost benefit analysis of the electricity to be, even if you determine that value and it's less than the usage rate, that you should still treat, excess generation, right, or usage as effectively energy efficiency, just reducing load. And then insofar as there's net exports, then you use that compensation rate you determine in the cost benefit analysis. Is that what you're saying?
Correct.
Okay. All right. Thank you very much, Dr. McCann. Those are all the questions I have. Ms. Blinn, Ms. Glass, Mr. Overstreet, do you have some cross-examination for Mr. McCann, Dr. McCann?
Thank you, Your Honor. Just a couple of questions. Good morning, Dr. McCann. I'm Kristen Blend, Internal Counsel for Kentucky Power.
Good morning.
Just a couple of questions this morning. You had a conversation with the Vice Chairman about the monopsony that exists in the net metering construct. Are you aware of the certified territories law in Kentucky?
No, I'm not.
Okay. Are you familiar generally with certified territories laws and what I mean when I use that term?
No, I'm not familiar with that term.
Okay. If there were a law in Kentucky that existed that prohibited the provision of retail electric service within a utility's certified territory by anyone but the utility. So, in that scenario, prohibited the sale of retail electric service by a customer generator or a QF. Would you agree that the monopsony that would exist would be a result of that statutory construct in the net metering?
Yes.
Okay. Now, there was a discussion during your discussion with the Vice Chairman, there was reference to the term power on the part of the utility vis-a-vis a net metering customer generator.
I'm sorry, you phased out right in the middle of the key word you were defining.
Oh, I'm sorry. There was reference to a discussion about market power on the part of the electric utility vis-a-vis a net metering customer.
Yes.
Do you recall that discussion? Okay. Do you agree that state, federal, and local regulation of utilities exists to ensure that electric utilities provision of service to all customers, including net metering customer generators, is reasonable?
No, I don't agree. I think that there are many times, I actually lived through the energy crisis in 2000, 2001 in California, in which the supposed protections that FERC could exert through against market power were inadequate. And only after FERC took very strong measures in March of 2001 did that energy crisis end. And there are other examples of where market power is a problem. In fact, there's good evidence that the blackouts in August of this last year in California were created by a exercise of market power by a small set of generators who exported power from the California ISO service territory when they should have actually been serving the ISO, which then served to drive up the prices that they received from the ISO. So no, I don't necessarily believe that the market power protections are completely adequate.
That's fair, and maybe I'll narrow the scope of my questions on this point. You would agree that the rate that Kentucky Power charges for net metering service going forward is going to be set by and approved by the Kentucky Public Service Commission?
Yes, and that's exactly the issue here is the contention over what is the protection against market power by Kentucky Power that is potentially that the commission should be exercising in this situation.
And you don't have any reason to believe that the commission will not properly authorize a rate that ensures that it's fair, just, and reasonable for net metering customer generators, do you?
No, if they fully consider the evidence, that's why we're here.
Thank you, Dr. McKinn. I have no further questions.
Okay, thank you.
Mr. Spinard, any redirect?
No redirect at this time. No.
Okay, thank you. Ms. Vinsel, can Dr. McCann be excused?
I guess he can be.
Thank you, Dr. McCann.
Thank you.
So at this time, if I could, to get counsel on the cameras, just so nobody can say that they didn't hear. We have a fairly quick turnaround in terms of the statutory date in this case. Today is April the 7th, and Ms. Vinsel, I understand that the statutory date is May the 14th. Is that right?
That's correct.
Okay. I think that.
Your Honor.
Go ahead, Ms. Blaine.
I apologize for the interruption. I suspect that where you're going to go next is to talk about procedural next steps. Before we do that, the company would request to recall Alex Bond for additional limited rebuttal testimony based on some of the cross of Dr. Robigo and Mr. Bills this morning.
Okay, and I guess I'm curious, on what basis?
The first basis relates to the experimental residential time of day 2 tariff, the company's tariff, about which Mr. Bills was questioned. That's a Kentucky Power tariff, and we believe it's appropriate for the record to be accurate and to reflect, the facts regarding that tariff, since it was raised and discussed during cross with Mr. Bills. Secondarily, there was testimony by Dr. Robigo about whether the company considered avoided distribution capacity costs in its net metering analyses. That question, I don't believe, was raised or addressed yesterday, and the purpose of the rebuttal for Mr. Bond would be to correct the record regarding what the net metering analyses, cost of service analyses did include with regard to avoided distribution capacity costs.
So before I ask for objections on that, on the second one, I would just ask, so you want to bring back Mr. Vaughn for the purpose of rebutting something that Mr. Robigo said about the company's case in chief, but that maybe the case in chief doesn't clearly state?
No, I think the case in chief is clear, but there's been full questioning of Mr. Robigo um, implied, if not stated, that the company did not consider avoided distribution capacity costs. And so I think for clarity of the record, it's appropriate to respond to that in this hearing record so that the hearing transcript or video transcript is complete on that issue.
Okay. Do we have any objection?
Can we take a brief break
Just, yeah,
Okay. To review? I want to review something in the record already.
yeah, do we have any objection?
This is Tom Fitzgerald on behalf of the joint interveners. I think if there's something that's in the record that they believe was not accurately reflected, that can be done in the post-hearing briefs. The case, there's nothing. Mr. Bills was not. His testimony did not speak to a tariff that is not subject to this supplemental hearing. We're here to talk about the net metering tariff. And I don't know that it is particularly helpful since he's already indicated that he has read the other tariff, but is not certainly, has not gone back and reviewed the case in 2009 when it was put in place. Ms. Blend has already indicated that nobody's taking service under it. So I really wonder if we need to be going through yet another round of questioning on an issue that is certainly tangential at best to the case in front of us.
Yeah, any other objections before you, it's a, 1 second, Ms. Blaine. Are there any other objections? Okay, Ms. Blaine, before we get to you, I'd like to take a short recess so I can talk to staff council. And then when I come back, I'll hear from you on your request and then roll on it.
Thank you.
Okay, we're going to go into a short couple-minute recess. Please, everybody stick around. Thank you, Anthony. Can you hear me, Miss Blend? Hold on one second. Our system's slow. Can you try again?
Yes, can you hear me now?
I can. Commissioner Matthews, are you here?
Yes, sir.
Okay, thank you. So we are going to recall Mr. Vaughn if he's available.
Thank you.
Yeah, and then we're just going to go through the ordinary process, and then we'll end with you with redirect so that we're efficient instead of trying to do direct, cross, and then redirect again. So you may recall Mr. Vaughn.
Thank you, Your Honor. The company recalls Alex Vaughn. And I understand from Mr. Vaughn that he's trying to enable his audio and video. He just texted me. Mr. Vaughn, I think we can hear you. Are you dialed in by phone?
Yes, I am now. I'm trying to get my video going here.
We can see you.
Okay.
There we go. Or technical problem. Sorry about that.
Okay. Mr. Vaughn, you are still under oath from yesterday. Can you hear us okay?
Yes, sir.
Great. Ms. Vinsel, do you have any questions for Mr. Vaughn?
Yes, Mr. Vaughn. First, I'm going to ask Mr. Leach and Mr. Rippey, can you please pull up to display Alex Vaughn's November 9th, 2020 rebuttal testimony? And we're going to go to page R28. And Mr. Leach, Mr. Rippey, can you scroll down to begin on line 13? Mr. Vaughn, could I have you read, and this is from your rebuttal testimony filed last November. Can I have you start reading on R28, on page R28, line 13? Through page R29, line 5, please.
Yes, it says reduced distribution level congestion, the company's highest distribution loading, peak loads in parentheses. Events happen early on cold winter mornings when it is dark. Net metering customer solar generating systems either have no impact on these peak loadings or a very small effect as the sun has just started coming up. Regardless of the fact, the company designed its distribution system to serve the highest peak load. Net metering customers' solar systems could reduce the loading on the circuit, but to do so in an amount that would be enough to defer a traditional solution, the generation amount would need to be significant and concentrated on the circuit where needed and at the time high loading exists. This is not the case in the company's service territory, and as such, there is no monetary value included in the NMS2 avoided cost rate for this item. Furthermore, I have been advised by company witness Phillips and that the company routinely conducts load flow analysis of its distribution system to ensure there are no load flow / loading in parens congestion issues.
So, Mr. Vaughn, is it your testimony that avoided distribution capacity costs are included in TARIFF NMS 2?
They're not in the avoided cost rate, they're on the cost side, rather than looking at when we did the cost allocation to see if the rates charged to these customers would be reasonable, we included a reduction for total distribution capacity costs based on the net profile of NMS2 of the net metering customers during the test year. So rather than looking at whether a specific substation or capacitor bank or switch would be affected by a customer's net metering system, we gave them full credit for a proportional reduction of total primary and secondary distribution capacity costs. So yes, it is included in the analysis. It's not included in the avoided cost rate. And remember, the avoided cost rate only applies to net excess gen above customers' loads.
So can I just ask, Mr. Vaughn, is the embedded cost of service study, class cost of service study you're referencing, the basis for your proposed compensation rate?
For the avoided cost rate?
No, you have a proposed compensation rate, in this case, for net exports of NMS2 customers during two different time differentiated periods, correct?
Correct. The rate is the same, but it applies to net billing units across two different time use periods.
Right, and there's a compensation rate for residential and then a separate one for commercial customers, correct?
That's correct, yes.
And are either of those, the basis of either of those, the embedded class cost of service study that you were just talking about?
No, because the embedded class cost, the excess generation is a marginal unit of generation, and the basis for those rates are the exhibits. I believe it's my exhibit 3 from my original direct testimony that was later corrected or updated for rebuttal items in my original rebuttal. And those avoided cost rates include avoided transmission capacity costs, avoided distribution losses, avoided energy costs, and avoided generation capacity costs.
Okay, thank you. Sorry, Ms. Nitzel.
No, thank you. Mr. Vaughn, do some of the substations peak in the summer?
They may, but it's not the company's highest peak demand on its primary and secondary circuit, which is what I've been advised by company witness Phillips and his team is that's what they're planning for, the highest peak.
I'm sorry, could you repeat that? I think I misunderstood something.
There may be a circuit that peaks at some point in the summer, like our generation peaks are in the summer, from a cost causing standpoint, PJM. But, I've been advised by company witness Phillips that our highest peaks are what his team plans to. And for our residential class, those are in winter mornings. That's, we have electric heating load, those distribution circuits peak for their highest total peak demand is winter mornings.
I'm sorry, one moment, please. Staff has no further questions for Mr. Vaughn.
Okay. I'm going to try to get this right. Mr. West. Any questions? Mr. Horn, any questions?
No questions from the Attorney General, Your Honor.
Thank you. Ms. Cohn?
No questions, Your Honor.
Ms. Grunman? We'll come back to Ms. Grunman. Mr. Fitzgerald?
Yes, Your Honor. Mr. Vaughn, can you hear me okay?
Yes, sir.
Okay. Mr. Vaughn, does the customer reducing their load through self-generation reduce the loading on the distribution system?
Yes, that's my understanding. They are consuming less load than they would be otherwise because they're generating behind their meter.
Okay. Did your analysis look at the local distribution level non-coincident peaks when you evaluated the impact of net metering on distribution costs?
So we looked at the entire profile, the 8760s of what these customers do in cost of service. So that includes all hours. They're by default, yes, non-coincidence was included. When we do rate design though and cost allocation, we look at class peaks, which aren't all coincident for the company. So yes, it's included. There's non-coincident peak analysis included, including an allocation of distribution costs. So to the extent those cost-causing peaks were reduced by the test year net metering profile, their generation was lower because they were generating during those peak hours. That has been included in our analysis of whether the proposed NMS2 rates are fair.
Okay, and is that based on actual data collected regarding the non-coincident peaks or actual load research based on your net metering customers?
Yes, that's what we discussed yesterday. We took a composite profile in Kentucky because that's what we have, and then we validated it against an actual load research study for residential net metering solar customers in our affiliate that is across the state line in Southwest Virginia.
All right, I have no further questions. Thank you, Your Honor.
Okay. Ms. Grunman, do you have any questions for Mr. Vaughn?
No questions, Your Honor.
Okay. Mr. Spinard?
No questions, Your Honor.
Mr. Miller?
No, thank you, Your Honor.
Mr. Fry?
No questions, thank you.
Dr. Matthews?
No questions.
Okay. Mr. Vaughn, I just a couple, because I guess color me confused. So the can we bring up, I think it's, and maybe Ms. Blaine can correct me, I think it's just Kentucky Power Company Exhibit 1.
Yes, Mr. Leach, Mr. Fry, can you bring up Kentucky Power Exhibit 1?
Which I think, Mr. Vaughn, this is the exhibit that Ms. Blend had you reference yesterday, which was the comparing the Virginia peaks to the Kentucky peaks.
That's correct.
For distribution.
Well, no, sorry, it's the Kentucky composite profile we put together for net metering customers compared to actual load research for Virginia net metering customers. And the comparison is done during the class cost of service class peaks that are used in the cost allocation.
Okay.
And so we did that to validate our composite profile.
Well, take a step back before we get into this then. For the cost of service study, do you allocate distribution for demand? Do you allocate that based on a 12 CP basis?
Yes.
So why would distribution, I understand and can appreciate, at least generally, why you would want to allocate generation or transmission as a whole on a 12 CP basis. But distribution system planning, it seemed like my conversation with Mr. Phillips yesterday, that distribution system planning, at least on individual circuits, is looking at the peaks and the need and the load on those circuits and on the transformers on those circuits. Was that your understanding as well?
The planning and the sizing, yes, is based on peaks on the secondary and primary system and various circuits.
But for the cost of service purposes, they're not allocated that way. Is that what I'm hearing?
No, I mean, they are allocated on peaks, but it's spread or normalized via 12 CP rather than like a 1 CP, and these are all you can pick 6 CP, 4 CP, 12 CP, a 1 CP. The 12 CP is used because it's more of an average calculation, and what you're bringing in here is that not all of the equipment used, all of the capacity costs, or fixed costs, non-variable costs of the distribution system are solely based on that one highest peak, right? There's a certain amount of equipment that's there regardless of peak.
Let me ask a clarifying question. Are you saying that you all allocate distribution costs on the based off the system peak or off of the distribution peak?
Well, it's the same thing if you're referring to distribution customers, right? Where we look at what the secondary system peaks are in the class cost of service study. We look at what the primary distribution peak levels are. We allocate based on those. So, right, you're not including your sub and transmission level customers in those allocations because they don't use the equipment, right? They're served at the higher voltage level. So if you're talking the total Kentucky Power System, no, it's not coincident to those peaks because it doesn't include your transmission and sub-transmission level loads.
Yeah, and on the other side, you may have circuits that are peaking at completely different times than the system, right? Distribution circuits.
Yeah, yes, absolutely.
And let me just that is not taken into account in the allocation of costs in the embedded cost of service study, correct?
Well, I would say it would be because we are using that 12 CP. So you're looking at, different classes month by month contribution to those peaks. So if you do have summer peaking circuits, that versus winter peaking circuits in total, that is included somewhat in this allocation.
Well, it's just included insofar as you're looking at the aggregate peak of all distribution in that month, correct?
On a secondary and primary basis, yes.
Okay, and when you're looking at a single peak within each month, you only get a 1 hour period in which to look at the distribution system in the aggregate.
That's right, the peak hour.
So when you say you're looking at the peak in this month, right? You may have in the summer you may have a distribution circuit that's peaking in the morning, and every other distribution circuit is peaking at, let's just look here at Virginia here, 3 o'clock in the afternoon in the middle of summer, right?
Well, these are the Kentucky dates. We're just comparing the Kentucky profile versus Virginia profile. This is the company's class cost of service peak days and hours that were used in cost allocation.
Right. Okay. So in July, the peak was at 3 o'clock in the afternoon, right?
Yeah. Yes.
Okay,
and
so,
as you can see, that we gave. Yeah. Go ahead.
So 8 a.m. 4 3 3 3 3 3 7 8 8 8 8. Those are the times of the peak using the 12 CP that allocates distribution expenses in the embedded cost of service study. Correct?
That's correct.
Okay. So taking that and knowing that those costs are being allocated on this basis, these distribution costs, and that these are the whole system in the aggregate, their distribution peaks, how does that compare to your testimony in your rebuttal testimony that says that the company's highest distribution peak load events happen early on cold winter mornings when it is dark? If you're only looking at the coincident 1 CP, sure, that's the case, right? Or it might be the case. But if you're allocating costs on a 12 CP basis, right, then how are those the same thing? How are you not able to avoid costs for the peaks on circuits in the other months of the year in which that distribution peak is not early in the morning?
The point is that we're sizing the system based on the absolute highest peak, but we're using, which is which is winter months, because we have a high penetration of electric heating for our secondary and primary customers, mostly our residential, and our small business customers. A lot of electric heat. We do not have gas pipeline infrastructure, natural gas pipeline structure like you have in some other states. So that causes those colder days, colder winter mornings to be the absolute highest peak. And when you go from what's causing the cost to how you're going to allocate the cost to make average rate, the companies use the 12 CP allocation. And while totally agree, the highest peak on the system is not those summer months on these in aggregate, but we're using the 12 CP to make average rates in the class cost service study. If you went to a 1 CP, it might result in shifting more costs just to the residential class, and for total equipment, that may or may not be a just and reasonable outcome. So you make the informed decisions in cost allocation, and this is what we've based ours on for as long as I've been doing Kentucky rates.
So the one of the sentences that jumps out to me in the rebuttal testimony is I guess it's the second sentence in section 2 that says, regardless of the fact, the company designed its distribution system to serve the highest peak load. After the testimony with Mr. Phillips yesterday, would you agree that maybe a more accurate sentence would be that regardless of that fact, the company designed its distribution system to serve the highest peak loads for each distribution circuit?
Yeah, I think it's saying the same thing, but no, the second sentence is at a more granular level. But again, what I've been advised by Mr. Phillips and his team is that if you're looking at our secondary circuits for our residential class, that highest peak, and I think that's included in the data in this case, the absolute highest peak you're sizing to is going to be on a cold winter morning because of the electric heat.
Okay. The last question I have on that rebuttal testimony is that the next sentence says net metering customers' solar systems could reduce the loading on a circuit, but to do so in an amount that would be enough to defer a traditional solution, semicolon, the generation amount would need to be significant and concentrated on the circuit where needed and at the time high loading exists. So you're talking about well, let me take a step back. You remember yesterday when I asked you about QFs, that they're paid the same kilowatt price for capacity, regardless of whether they're I think the one I used was 1, 3, or 5 megawatts?
That's right. They have a unitized rate.
Okay, and again, if that calculation for avoided capacity cost was based off of deferring an 80 megawatt generation, it doesn't matter that none of those individually or even in the aggregate can actually defer the entirety of the calculation, the generation used to calculate avoided cost, right?
That's right.
So
You're avoiding a part of that investment.
Yeah, so why for distribution avoided cost here, you're saying that instead of it being a portion of it, for distribution avoided cost, it would only be reasonable for it to defer the entirety of the investment?
That's not what I'm saying. What I'm saying in this testimony, in this rebuttal, we were talking about the avoided cost rates. And I'm saying that avoided cost rate applies to excess generation from a net metering customer. And that excess net metering is not based on our system and my discussions with Mr. Phillips and his team. That we're not deferring distribution investments, based on excess generation from net metering customers in the afternoon. And the way that we have incorporated the net metering customers' actual load reductions into distribution avoided cost is on the load side of the equation. What is the right rate that they should pay for net billable kilowatt hours? And we did that through what were demonstrating in this exhibit, where you can see that we reduced their cost allocators in the class cost of service study for when their generation was was reducing their load to zero. So you can see they received a lower allocated cost of total distribution than the normal residential profile, normal residential class received. So you have to look at it in two distinct pieces, right? You have an export rate for excess generation, and then what are the right rates to charge these customers? And we've proposed standard tariff rates, and that was validated by the class cost of service in this whole process that we've been discussing.
So, but you did that embedded class cost of service study months after this testimony. But in this testimony, the sentence I just read, you said, absent the ability to defer the entire net metering customers could reduce loading on a circuit, but to do so in an amount that would be enough to defer a traditional solution, semicolon. The generation amount would need to be significant and concentrated on the circuit where needed and at the time high loading exists. This is not the case in the company's service territory, and as such, there is no monetary value included in the MMS2 avoided cost rate for this item. So, one, if that's not the basis for the determination of the avoided cost rate for capacity, for instance, why should it be the basis for the avoided cost rate for distribution? To defer the entire investment.
Well, again, my point is, and this is based on my discussions with Mr. Phillips, this informed this testimony in my original rebuttal back in November, and it's specific to the export rate, the avoided cost rate, is that, there was multiple things that had to happen to actually delay or completely avoid a distribution capacity investment. And those are those things we've laid out that we've just read through a couple times. And it was, my understanding from my conversations with him that we are not observing that, right? And so you would need all those things to happen. You need the extra generation to happen on a circuit where you have congestion. He's advised that we don't have distribution level congestion, and it has to happen at a time when the peak loading is happening on that circuit. Right, so if it's happening on that circuit, but the peak loading is happening in the morning and the extra generation in the evening, you're not deferring anything.
So
you have to actually contribute to the peak.
Isn't it then a chicken and egg situation that either you provide a price signal to incent people to actually come there and offset load or reduce the load necessary on a particular circuit or all circuits to reduce, future investment, or you just wait around until a big enough load comes and then you pay them that, right? With avoided capacity, for instance, aren't you sending them the price signal ahead of time for you to defer a cost that you expect to incur in the future?
That's the point. We don't control where these things come on. They can come on the system wherever a customer takes service from us. And so it's hard to directly attribute to them in an avoided cost rate some known reasonable amount of avoided distribution capacity cost, because you may or may not need more distribution capacity on circuits that they come on. Which is why we chose to value it in the rate side, what they're actually paying for net billing, and actually what they're being compensated at for all of their netted kilowatt hours.
Okay. So you all made the decision to include this in the load side prior to you all even conducting the embedded class cost of service study?
Yes, it's implicitly in there because our proposal is that during those netting periods in NMS2, customers are still compensated at the full retail rate for any generation that nets their load behind the meter.
isn't any cost or benefit that actually exists that's not included in the compensation rate implicitly included in the embedded cost of service study?
Can you say that again?
Isn't any real cost or benefit that's not explicitly included in the compensation rate implicitly included in the embedded class cost of service study?
I'd say all of the company's actual accounting utility cost of service are included, yes, in that cost of service study, the embedded cost of service study based on test year amounts.
Okay. All right. I appreciate it, Mr. Vaughn. This has been very helpful.
Thank you.
Ms. Blend, I think it's Ms. Blend, right?
Yes, Your Honor.
You have any redirect?
Thank you. I just have a bit of follow-up regarding PSC Staff Exhibit 3, which is the Experimental Residential Service Time of Day 2 tariff in Kentucky Power's tariff book.
Would you like us to bring that up, Ms. Blend?
Mr. Vaughn, would you like to have a copy in front of you?
I don't think we need one, but if it helps, sure.
Yeah, I think my questions are basic enough that we don't need to pull up the tariff, but thank you, Vice Chairman. Mr. Vaughn, you were listening to the testimony and the questions asked of Mr. Bills, Joint Intervenor Witness Bills, regarding this tariff. Is that correct?
It was.
Can you please state for the record when the tariff RSPOD2 was first put in place or first approved by the Commission?
Yeah, I think it was approved in our 2009 rate case.
And since it was approved in the 2009 Kentucky Power rate case, how many customers have taken service under that tariff?
Well, during the test year, we had 0 customers taking service under it. I have myself never observed a customer on it. That's not to say that someone hasn't gone on and come off it in the last decade, but very few to none.
Okay. Thank you. Could you please describe or address the question of whether the rates in that tariff are cost-based rates?
Yeah, they're definitely not cost-based. I mean, you have a 19-cent on-peak cost of electricity, and that simply does not, jive with the company's actual cost of on-peak power. It's a kind of a policy-based rate, right? It's an experimental rate where you're providing a non-cost-based, essentially penalty price signal for customers that may have loads they can move. They're time differentiated. They can move them around on peak or off peak to discourage on peak usage.
Thank you. Do you recall a discussion regarding the fact that with Mr. Bills regarding the fact that this tariff is seasonally differentiated, whereas the NMS2 tariff, as compared to the NMS2 tariff? Do you recall that going? Okay. If the Commission were to set the avoided cost rate under tariff NMS2 at LMP, would that rate be seasonally differentiated?
Yes, if you used LMP as the basis for the avoided cost of energy, it would be hourly and seasonally differentiated.
Thank you. I have no further questions, Your Honor.
Okay. Thank you, Ms. Blend. Thank you, Mr. Vaughn. Ms. Vinsel, can Mr. Vaughn be excused again?
Yes, he can be.
Okay. Enjoy your day, Mr. Vaughn.
Thank you.
Let me just re-ask. Are there any more witnesses? Okay. So hearing nothing, if I could get counsel on the screen, that would be great. Do we have anything else that needs to be addressed today? Any requests, any motions? Okay, hearing none, I've been scribbling and looking here at the calendar, and like I was saying earlier, we have a statutory due date of May 14th is our understanding that we must get an order out prior to. And so that gives us, a month and a week effectively. So I have sketched out here I know we have the commission staff will have some data requests that have come up. I think maybe there were one or two from the parties. So at this point, I'd propose that data requests are due tomorrow at 12 o'clock, the 8th before 12:01, and that the responses are due by the 14th at 12:01 as well. Now, I think at this point, my understanding from this hearing, Mr. Overstreet, is that the company is the only party that's been asked questions that there's an expectation that there will be data request responses from. I don't think that anybody else has indicated anything different. Is that your understanding?
That's my failing memory.
Okay. So I understand that 6 days is a fairly quick turnaround on those data requests. And so our hope is that the 14th will work. And if there are specific items that you all need additional time for, just ask that you make a motion for those specific items. But as a general matter, attempt to get the bulk of those by the 14th. Is there any objection?
No, obviously we will do our best to get all of them answered by the 14th, but appreciate the opportunity to seek a deviation if required.
I've always found that if it's 100 questions or if it's one question, there's probably, or 10 questions, there's probably one that's a little more difficult than the rest of them, especially when it's, I think some of the data that we've asked for from the distribution group may be tougher to get than others. At this point, for a briefing schedule, again, given the short turnaround that we have, I've initially sketched out that initial briefs would be due on the 16th, with responses due on the 21st, and a reply brief on the 26th. And I'll just be honest with you, Overstreet. My thinking there is that you all have kind of already put your case in chief on once, and that maybe additional days there to do a reply brief, particularly to see what has come up in the response briefs, may be helpful. Do you all have a concern with those dates?
I would look to Ms. Blend, but for clarification, would Kentucky Power be filing on the 16th, interveners on the 21st, and then Kentucky Power replying on the 26th? Is that your thinking?
That's right.
Okay. Ms. Blend, is that?
I guess I'm wondering, based on the schedule and the data response schedule, whether it might be appropriate for the parties to file simultaneous initial briefs and reply briefs, such that any party who wanted to file a reply brief could do so, but that all of the briefing would maybe be due April 21st and April 26th, respectively. That would, I think, give the company a little more time to focus on the discovery, prior to the 14th.
I have no concern with that. It's you all that you all have the burden, as you stated earlier. So I'm certainly deferential if that's your preference. So that you would ask that everybody has an opportunity to file an initial direct brief on the 21st, and that all parties would be able to file response briefs on the 26th.
May we have just one moment to consult amongst counsel for the company? I'm sending a text message to Ms. Glass.
That'd be fine.
If you wouldn't mind, Your Honor. Thank you.
And Your Honor, since I'm a dinosaur and don't text, I will join Ms. Glass next door.
Okay.
Mm-hmm.
Okay, we have conferred, and yes, that's our proposal.
Okay, so we will enter an order today setting the data requests will be due by the end of the day on the 8th, which is tomorrow, to be responded to on the 14th by the end of the day. Initial briefs in which all parties may partake on the 21st of April, with responses due on the 26th. Are there any objections to that?
No, Your Honor, I do have a question. On the data request, you indicated earlier that it was 12:01 tomorrow, and then you just said end of the day tomorrow. Could you help me understand, are we talking 1 minute past noon or
Sorry.
1 minute past midnight tonight?
1 minute past, at the end of the day, at the very end of the day, 12 o'clock. Yeah.
Okay, thank you.
12 o'clock midnight. We have to accommodate Mr. Fitzgerald.
That's right. That's exactly who I was thinking of.
You can set mine at 11:59.
Yeah, I tell you, if we need to make sure that if we ever set our website to, sometimes you see a message on a website that says that's going to be down for maintenance and it's always this, time that's not going to inconvenience everybody. I've found that that's probably the scariest message Mr. Fitzgerald ever gets, that it's going to be down at 11 o'clock on a Tuesday night. So,
Vice Chairman, having been born 4 days after my due date and having spent the entirety of my life trying to catch up and be on time, the fact that I'm able to make that day at all is a minor miracle.
Well, we're always happy. We're always happy to see that somebody's working after we leave, and it's usually you about 10 or 11. So yeah, at midnight on the 8th and at the 14th. But we should have our data requests out probably early tomorrow, Mr. Overstreet.
Thank you, Your Honor.
And so just to be clear, I think we have an expectation that given that everybody has agreed to this briefing schedule, that there will not be any requests for a reply brief. So just sort of be on notice about that if it's going to be requested to have an initial response, that our expectation is that there would be no further requests or leave to file a reply brief. And so we will submit the case on the 26th, and with an order expected out before May the 14th. Are there any other questions or anything that needs to be taken care of before we adjourn? Okay. Hearing none, thank you all very much. Thank you for bearing with me and bearing with our technological. We're always learning something. Maybe in a few months we'll be back doing in-person hearings. Only one can hope. So thank you all very much, and we're now adjourned.
Thank you.